Patrick. Hi, everybody. I'm Patrick. This is Tigger. I have 30 minutes to discuss a topic that has been discussed for the past I don't know how many years, and literally millions of comments from millions of people. Plus, I'm going to throw a few extra things in the back just because I like a challenge. So, this agenda, just so that everybody is clear, what we're talking about is the NPRM, the Notice of Proposed Rulemaking. It's only 99 pages. You've all read it, right? Well, if you haven't and you have a little bit of insomnia, let me tell you, this is the way to go. Way better than Ambien. So the other thing that we're going to talk about is a little bit of quality of service and some paid pairing implications. Oop, I went backwards. Look at that. There you go. A few things. These are my opinions, not other people's, even though they should be. Very specifically, I'm excluding people like my employers and the organizations where I'm on the board and things like that. This is very high level due to the time constraints, sorry. I'm trying to be unbiased. If you see something that sounds biased or whatever, just raise your hand, talk about it. I encourage questions. And remember, I am not a lawyer. In fact, I'm not even an ISP. So what is an NPRM? An NPRM stands for Notice of Proposed Rulemaking, and yes, the FCC does make that one word, rulemaking, and don't ask. Anyway, I personally think it's probably one of the most clear acronyms that any government institution has ever put out. It means exactly what it sounds like. They are giving you notice that they have a proposed rule that they are going to make. So new rules require comment period. There's actually a few things that usually go along with an NPRM. This one was quote unquote fast-tracked, so they skipped a couple steps. But there's a long public comment period, which is technically over. If you know what you're doing, you might be able to get something in, but we're not going to cover that. The important part about this is if it is passed, the rule will have the force of law. The FCC it's not 100% unique. It's not like this has never happened before in the history of the US government, but it is true that when the FCC makes a rule, that has the same force as a law that Congress voted on and the president signed. And that's a little unusual, at least in our government. By the way, lots of people have, I sent out this presentation to a few people to get comments for obvious reasons. And some people pointed out that this is not an actual NPRM, at least not a typical one, because if you read through it, it doesn't actually have the text that said, this is the actual rule we're planning to put in. It just says, this is what we would like to do in general terms. So some people argue it's not an NPRM. Some people suggested it was an NOI or something, but let's not go over that. So the motivation for the NPRM, it was a court case, Verizon versus the FCC. The Federal Court of Appeals, this is important that it's Federal Court of Appeals. In the US government, that is the second highest court in the land. There are several of them, but they're all at the same level. The second highest court in the land decided that the FCC did not have the jurisdiction to do what it was trying to do in its open internet order. When most people talk about network neutrality, what they're actually talking about is the FCC's open internet order, which in general says what some people think of network neutrality, even though network neutrality is such a nebulous term that it's really hard to pin down. Specifically, and these are the things that nearly everyone can agree on as part of network neutrality, the non-blocking and non-discrimination portions were very, very specifically shut down. They were not allowed under this. So, and the reason that the the appeals court said that is they said the FCC claimed that ISPs are not common carriers. If they're not common carriers, you cannot bind them on their commercial agreements. You can't say they're not allowed to, for instance, charge one person more than the other. And I'm actually going to give you a specific example of that. Anyway, the chairman of the FCC, well, the FCC said that they're going to recast the rules, and they're still going to use Section 706. And there's a lot in here. If you read the ruling, there's actually part of Section part of the ruling that says Section 706 could be used if you redo it this way, but it's kind of a stretch, in my opinion. Again, not a lawyer. So the FCC is going to recast the rules, try to get it right so that it can get past the courts, although the chairman has said that all options are on the table. For those of you in the UK and stuff, on the table in the US means that it's still available for consideration. It actually means the opposite of that in the UK. So what he was saying is essentially, if we can't get it done with 706, we might actually consider Title II, and that's what we're going to talk about. Lots of people think that Title II is better suited if you're going to have an actual open internet order, network neutrality style regulation. So, Title II protections. We're going to start with Title II. Title II, if you classify ISPs as Title II, that makes them common carriers. That's what your telephone is. It has a lot of protections in it for both the corporation providing the service and the user using the service. It also has a lot of responsibilities, but we're going to start with the protections. First of all, things like anti-blocking and anti-discrimination are automatically built in. Just as an example, using the telephone service, AT&T cannot decide that they're going to charge Company 1 more than Company 2 because they like Company 1 better. There are things called tariffs, and they must charge the exact same price for the same volume to everybody who asks. And there's lots of caveats that go, and it turns out that most phone service these days is not tariffed, but that doesn't matter. The point is that under Title II, everything is set. You have no choice. There's a lot of negotiation room that is taken out of the ability to do things. It also protects the carriers, not just the users, not just the people trying to buy the service. It protects the carriers. So, for instance, the DMCA has a lot of protections for ISPs. As a Title II, they essentially have 100% protection. Under the DMCA, if somebody sends you a note and says, oh, this thing is copyrighted, you have to take it down or you could be in trouble. Under Title II, theoretically, there's a lot of worries around this, but theoretically, you can't blame me for anything because I'm a common carrier and I just have to do what I'm told and I don't have to worry about what's going over the line. The canonical example of this is the phone company can't be sued for somebody picking up the telephone and dialing a murder for hire. They're completely 100% not responsible for it. Same might be true of ISPs. Again, lots of caveats apply. So responsibilities. This is the part where people are upset. And it's not just the carriers that get a little itchy around Title II. There are lots of non-carriers that don't want ISPs classified as Title II because of these responsibilities. So first things first, I've already said the word caveat like 100 times, but we're going to do it some more. Not everyone agrees that if you make an ISP a Title II, exactly how that will work legally. So we've talked a lot about how the phone system works under Title II because it's already been done, and it's been done for decades. It is not clear what would happen if you make broadband Title II because it's not a telephone and there's not a lot of case law around it. In fact, there's none. So it's very unlikely that everything that an ILEC had to do, an ISP would also have to do, but it's also very likely that some of the things would flow through, and these are the problems. For instance, it is entirely possible, not guaranteed, but it's entirely possible that the government would suddenly decide that if I'm going to pair with you, that they get to stick their nose in and decide when, where, and how much, because it'll be tariffed. And I won't be able to negotiate or any other way to get around the fact that if I want to connect to ISP A and ISP B want to connect, they must go to the government, find out how much the cost will be or what the rules are around it. As you can imagine, that's pretty horrific. It might also, for instance, again, just throwing things out there as a hyperbolic example, you could theoretically have something that would be like universal access, where every home in the United States had to have a certain level of broadband at exactly the same price. There's some low level that for, I don't know, 40, 100, who knows, dollars a month, every single home in the US would be given a guarantee that they could buy a 25 or 50 meg broadband at that price. That is not out of question if ISPs are made Title II. It's not guaranteed, but it's not out of the question. There's this thing called forbearance. So if the FCC forbears, and that's the technical legal term, they could decide that, and this is, by the way, 100% within their purview. They're allowed to do this. They've done this before. There is no question that this is allowed and legal under the rules. They could make ISPs Title II, a common carrier. Then they could forbear. They could say, you know what, we're not going to get into the peering thing. We're not going to do universal access. That's perfectly fine and legal, and it is allowed. Most people, in fact, everybody that I talk to who've even heard of the word forbear, believe this is exactly what would happen. The reason is that everyone, every person, just about, like 99% of the people in the United States would want them to forbear. Not just the users, but the carriers. Remember, carriers are really good at lobbying the FCC. AT&T has literally a century of lobbying expertise, over 100 years. They don't want it to happen. And the users don't want it to happen. Most users don't. There are a few on the outside, but most people, most large corporations, most content providers, most ISPs, most ILECs, most of everybody would want the FCC to forbear. So they will. At least that's the thinking. The second thing is if the FCC does not forbear, the total metric tonnage of unintended consequences that would be really bad for both the economy and the users in general cannot be counted. So again, FCC almost assuredly would forbear. And this is the argument most people use on the Title II side, saying we want the common carrier protections and all the bad things can just be forbeared. Life is good. But then there's the other side, Section 706. So a lot of people talk about 706, and I've gone to conferences. I've spoken in front of like congressional staffers and stuff, and everybody's all like, "Oh no, I like 706 better." And if you actually ask them why, they're like, "I heard it on TV once. I don't know." It turns out 706 is not regulatory. Read Section 706. This is the second most boring thing you will ever read, right after the Open Internet Order. The NPRM. So 706 was actually not written to regulate anything. It was written to explain that the FCC should promote broadband, not regulate it. It should promote it. It should make broadband happy, I guess. I don't know. But that's the idea behind Section 706. The FCC has claimed, and the court actually agreed, that by things like open internet protections, i.e. network neutrality, they create a virtuous circle which creates investment and innovation, which they view as promoting broadband. If you ask me, that is the most torturous way I've ever heard of having somebody start regulating something, but whatever. So the nice thing about 706 is there are practically no requirements because it's a promotion thing, right? You don't have to worry about tariffs and universal access and 1,000 other things that Title II carries with it. So a lot of people like 706 better, but other people will say it was not written as a regulation. The court already said that you can't use it as that, although the court did leave open the idea that if you rewrote it in some special way, maybe 706 could be used. But it's kind of convoluted. So this is the biggest problem that lots of people have with Section 706. Let me actually just read this thing for you because it is amazing. This is actually in the court response. If you go and read the U.S. Court of Appeals judgment, they said Verizon might charge an edge provider. I love the fact they call people like Netflix edge providers. Might charge an edge provider, Netflix, for high-speed priority access while limiting other edge providers to a more standard service. Translation, they could sell QoS to Netflix and not Hulu. Flat out, the court said that not only could that happen, that was the only way it could happen under 706, given the way the rule was written today. In theory, not only could Verizon negotiate separate agreements with each individual edge provider regarding the level of service, it could charge similar situated edge providers completely different prices. So it could go to iTunes and say, hi, you're going to pay me $10 a megabit, and go to iPlayer and say, hi, I'm going to charge you $5 a megabit for exactly the same thing. And the way that the court came to that conclusion was that if you start with anti-blocking, you must not disallow not disallow anti-discrimination. That was too many negatives. If you start with anti-blocking, you must allow the providers to discriminate. They can negotiate different deals with different, they say edge providers. I'm going to call them content providers. It's kind of worrisome. So moving on, the NPRM tries to make things fair. The new NPRM tries to make things fair, tries to get rid of exactly what the court just said that they must do. It says things like, if you're going to allow QoS for VoIP traffic, you must sell it to all VoIP providers. And you must sell it at the same level and the same price. Exactly what the court said you couldn't do. Essentially making it a tariff. Without setting the price, it just said you had to, whatever the price is, allow it to be for everyone. So proponents of Title II say that you can't fix that in 706. So whether they can or not, I'm not a lawyer, I don't know, but that's the argument. The FCC has left reclassification, i.e. using Title II on the table, but they're still pushing down the 706 path. So there's a few alternatives to Section 706 and Title II. The FCC could close its eyes, right? It could just do nothing. That is actually open. to the FCC. They're allowed to say everything's working. In fact, when I talk to some people at the FCC, you get things like, oh my God, they're charging this many tens of thousands to this content provider. And the people at the FCC go, wait a minute. You know, big ISP makes how many billions a year, and you're talking about $10,000 a month. Why am I even involved? They actually begin to wonder why this is important, because you've got these gigantic billion-dollar corporations arguing over a few $1,000 and trying to get this massive government entity involved. And you have to explain to them there's a little more going on than just that, but this is actually one thing that has come up. Well, maybe we should just leave it alone because it's really not important enough to matter. The second thing is Congress could vote in a new law and the president could sign it, which, if you know anything about the US Congress, know that will never, ever, ever happen for the rest of our lives. So the FCC could use its promotional powers. It has, for instance, a lot of money that it uses for something called E-rate. I'm just using this as an example. But it could say the E-rate funds only go to providers that agree to the open internet order, which is therefore not guaranteed. You know, you could ignore it and just forego the E-rate. This has actually been, in the US government, a good way of getting people to do things. They spend money on roads. If the state doesn't do what the federal government wants, then that state doesn't get any road money. Suddenly all 50 states do exactly what the federal government wants because there's too many billions of dollars in road money to be spent. This is a way to do it. Unfortunately, the amount of money that the FCC has to spend is not enough to guarantee that everybody would do stuff. As a result, none of these seem likely. So the most contentious part of the NPRM, and sorry about the transition, I'm running out of time, is the quality of service. I mean, besides 706 versus Title II. The NPRM allows broadband providers to configure QoS on the end user connection. Just so that we're clear, that didn't say peering. That said end user connection between you and the cable, the head end, you and the BRAS, well, I guess maybe the DSLAM, I forget exactly what, but only on that part of the network. That's where the NPRM is suggesting that you should be allowed to QoS things. So, everybody knows what best effort is, right? It's lawyer speak for commercially best efforts, right? It's the idea here is that most ISPs, when you send them a packet, they're going to try and get it there as hard as they can. If they can't, too damn bad, they tried. And they want to do that because some packets will get dropped and they don't want to get sued. And that's the way it is. QoS tries to solve this problem, tries to give the user a guarantee. But it doesn't work for everyone because if you don't pay extra, you're not guaranteed. And frankly, just so that everybody in the room is clear, it doesn't work all the time either. If you have 11 gigabits of QoS traffic on a 10 gigabit link, some of it's going to get dropped. I don't give a shit how many bits you set in that header. So another thing that, and I'm sorry if this is a little bit basic for some of you, but it's amazing how many people don't realize this. QoS is irrelevant if there's no congestion. There's no need to prioritize. There's no need to jump to the front of the queue if the queue length is 0, right? So during congestion, every packet that gets prioritized deprioritizes another packet. This whole idea of a fast lane, it's kind of silly, right? Something will get dropped if there's congestion. You're just picking which ones will get dropped. And if there is no congestion, QoS doesn't matter. The fast lane thing, the way I like to think of it is analogies are like bicycles. It doesn't matter how many marbles it takes to fill the outhouse. Telco execs will always be making silly metaphors. And I said that to a telco exec, and he went, wow, that makes a lot of sense. So a quick refresher on QoS, simple diagram. For every additional green packet, a red packet is discarded. It's really, really that simple. If you QoS something, something else has to be non-QoSed, unless there's no congestion, in which case QoS doesn't matter. So those are the two possibilities. Those are the two choices. The drawing is a little simplistic. I had to show it in front of Congress, so I had to dumb it down. So I like to think of quality of service as quantity of service for these reasons. Like I said before, jumping the queue is not relevant if the queue length is 0. There's no line to get to the head of. So just remember, quality of service means that I don't have enough bandwidth, but if you pay me more, I'll drop her packets first, or apparently the clicker. So the interesting part about the QoS in the NPRM is that broadband providers would be allowed to charge for it. And if a company can charge for something, they will charge for something. At least that's how I run my company. Anybody who doesn't, kind of silly. Some claim this will stifle innovation because, you know, if you have to pay millions of dollars to guarantee good performance, then how is the next Google or Netflix going to start in a garage? Anybody here know what the hell the next Google and Netflix is? And I don't mean the actual thing. I mean, like, what does that saying even mean? So, but that's what everybody says. So I don't know if this will stifle innovation, but that's been brought up a lot about why QoS should not be allowed on the broadband network. So the other thing that people bring up is a moral hazard. If I'm allowed to charge for QoS, will I have an incentive to congest? So first of all, we're just going to leave aside the fact that they already have an incentive to congest today. Sorry, they are congested today. So we're going to just move on to the fact that this is the end user connection. Now, cable modem is a little different than DSL, but in general, I pick how fast my broadband connection is. And if I have DSL and I'm connected to a DSLAM somewhere, then that connection is dedicated to me and I pick how fast it is. How are they going to congest? This part doesn't really make sense to me, but a lot of people bring it up, so I'd like to just throw it out there. The other thing that is interesting about this is, will broadband networks really make more money by selling slower pipes to their users and then trying to make it up on QoS cache? I just don't think that's going to work. So this particular thing, I don't think the moral hazard really bites. The one before that, maybe, maybe not. It's a little unclear to me. But in general, there's lots of reasons why QoS could or could not be bad. So the other thing is Netflix versus Comcast versus Verizon versus apparently, and I didn't know this until I got to NANOG, AT&T, and Time Warner. Apparently they have publicly announced that they have deals with all four. I did not know that. But that's what I was told by a newspaper reporter, so it must be true. So some people conflate the recent announcements by Netflix, and by the way, I should caveat, the reason I'm using Netflix is not because they're special or because I like them. I'm not even a subscriber, to be honest. The reason I use them is because they publicly announced this, so I can talk about it without revealing NDA'd information. But anyway, a lot of people talk about the Netflix thing as if it's part of network neutrality, as if it's part of the NPRM, and it's not. In fact, John Oliver gave, by the way, a hilarious skit on this. I really did like that skit. But he talked about the Netflix thing, and he had some really good points on it, but he talked about it as network neutrality. And what most people think of as network neutrality, namely the open internet order, is not covered here. It's not covered. It's not the same thing. The NPRM allows QoS on the broadband end user connection. This has nothing to do with that particular connection. Even if it were enforced, and it's not enforced today, Netflix is not prioritized on that link. Now, just as a side note, there is some QoS today. Some broadband networks are QoSing some things on the end user connection, but it's not for sale to third-party networks yet. So, if they're not getting QoSed, what do they pay for? Again, had to present this in front of Congress, had to be a little dumbed down. So, pardon the simplicity of the diagram. So Netflix got a fast lane, sorta. They got a direct connection into the core of the network, bypassing the peering/transit edge, which was congested. So they avoided congestion. And that was what they paid for. It's paid peering. It's not terribly surprising. Most of you probably knew this before I put the slide up, and lots of people have done this in lots of ways. Netflix is paying for a dedicated path into the broadband network to avoid congestion, right? The NPRM would not change that. It doesn't talk about peering. It doesn't change the fact that the providers can still charge for peering. It doesn't even regulate the amount of peering or transit they have to have, so that doesn't mean if the NPRM went into effect tomorrow, if Netflix did not buy the path around the congested edge, QoS on the last mile probably wouldn't matter. Totally different things. And I did it 5-something minutes for questions. I'm good. Seriously? This is one of the most contentious topics in the history of NANOG, and you guys have 0 questions. Brandon, who are you? Who are you?
Brandon Ross, Network Utility Force. Is there any, in your observations among the government people, is there any thoughts that perhaps service providers should be regulated differently depending on whether, as far as these sorts of things go, as far as whether they've already received some sort of advantage in the marketplace based on government regulation? In other words, if I'm compelled to allow you to run your cable in front of my house and my property, maybe I have some say in what kind of net neutrality stuff you can do, and if you're some other kind of provider that doesn't have that kind of advantage, maybe that should be your own business. Not that I'm stating my own opinion about how these things should work.
In general, the people to whom I've spoken did not break it out that way, no. Doesn't mean that nobody has. I haven't spoken to every person in government, but in general, no, that's not the feeling. Sorry. There's an FCC guy here tomorrow. You can ask him. Any other questions? It's a race. I think Donnie's going to win. No fair. His microphone was closer.
Yeah. Hi, Donnie Roisman from SoftLayer. So, just the cliff notes here. Title II. If broadband providers do fall under Title II in the future, if that's the decision that's made, does that put the openness of peering in jeopardy at all, or is this a non-issue like you just said towards the end here?
So first of all, what I said at the end is if the NPRM goes into effect, which as written right now is not under Title II.
Oh, it's okay.
So if ISPs are classified as Title II, then yes, it does. There's risk to the peering ecosystem that the government will then start regulating it in weird and unintentionally bad ways, maybe intentionally bad ways. But most people, including myself, believe the FCC would forbear those requirements of Title II on ISPs for many of the reasons that were listed. So the short answer is yes, but chances are no.
So there's no clear answer.
No, there isn't, because the clear answer is that, well, first of all, there's no clear answer because if Title II is done, then we actually don't know what will happen. But if Title II is done and the FCC stops at that moment, then chances are peering will be affected. But everyone that I know, and like I said, including myself, believes that the FCC would forbear at least many of them. How many of the requirements they would forbear? Like, would they just totally ignore peering? That's up for question, and who knows?
Yeah, thank you. And thank you for taking the talk, by the way, to the government and representing us. Appreciate that.
At PTAC, Yahoo. So you said you went to government, you pitched this, you opened their eyes. Can you give us a 30-second view of what their reaction was and whether you felt that your educational efforts actually brought them any closer to understanding this?
Okay, so first of all, what I pitched to government was not this presentation. I redid it quite a bit to present here. Those drawings I stole from the other presentation because I'm lazy. I spoke mostly to congressional staffers, and they are actually bright, willing to learn, intelligent, trying to help people. They mostly, by and large, got it, but reasonable people can disagree, and there were some real questions about lots of things. In fact, interestingly, some people in government going, but when has the government ever run anything that worked? And I was like, seriously? But yeah, they seem to get it. The problem is that the staffers and even the Congress people themselves don't actually, a few of them don't really matter. And I know this is being recorded, so I'm going to pick my words carefully here, but let's just say that there are other influences at work. Next.
Adam Thompson, Manitoba Internet Exchange. I just wanted to make a comment, actually, not a question. You were questioning whether ISPs would be incentivized, whatever the word is now, to not sell higher capacity links to end users. And in any rural or wireless situation, yeah, that absolutely is the case because there's a strong economic incentive to provide lower speed links to end users.
Right, but that has nothing to do with whether QoS is allowed on the link or not.
No.
Right. So if I'm already incented to lower your speed, then yes, that's true, and I'll try and lower your speed. But that doesn't change if I now have QoS. Next, I think we have time for at least one more.
Hi, Chris Woodfield, Twitter. the history of regulated utilities, telecom, you know, cable television, what have you, has always been based around whether or not a service is a natural monopoly or not. And I think that, and my question is, do you think that the FCC staffers have this idea that broadband right now is kind of in a gray area, whether or not it is in fact a natural monopoly, and that changes from location to location? And that does complicate the rulemaking. Do you get a sense of the FCC staffers wrestling with that question?
So, kind of out of time, but I'm going to just go ahead and answer this. The sense I get talking to the people in Washington, D.C. is that they don't actually feel that broadband's a natural monopoly, which I'm not sure that is the right way to think of it. And part of this has to do with the fact that they get talked to very, very frequently. Like when I was talking in front of these people, there was an AT&T person sitting, you know, two chairs down from me, explaining how, or somebody from the CEO of the ITIF saying, oh, the U.S. has way more choice than most countries in the world, without pointing out that most countries in the world don't have broadband at all, you know. So they get a lot of, what's the saying, lies, damn lies, and statistics. And I don't know if you guys have noticed, but the chairman tried to raise the definition of broadband from 4 meg to 10 meg or 25 meg, and AT&T put out this, and Verizon put out this statement saying 4 meg is enough for everybody. And in my head, all I heard was, didn't you mean 640K is enough for everybody? But they get told this a lot, and they don't know a lot of what's going on. So when they say, look, you've got broadband and you've got cable and DSL, so clearly there's a choice. But no, they don't view it as a natural monopoly. Am I allowed to take one more?
Mike Joseph, Google Fiber.
Google Fiber?
Yeah, Google Fiber. We may have a horse in this game. So you could barely get a half dozen people to come up and ask you questions about this topic at NANOG. How do you get the public interested in this?
So there have been more comments on the NPRM to the federal website than ever in the history of anything at the government. So the public seems to be interested. The problem is, and I did actually go and talk to people about this, most of the comments are being, let's not call it ignored, but not taken seriously because they're very emotional and they're not written in consultant speak. And so as a result, people like the large corporations that have lawyers that write these things that the people in government are used to reading, they tend to get more weight. And that's just a fact. I'm not trying to like say that the government's doing anything wrong or that the corporations are doing anything wrong. That's seriously a fact. So the people seem to be involved, or at least motivated. I mean, after the John Oliver skit, the FCC server crashed from the number of people trying to comment. They're not saying it in a way that the government can actually do anything about. Yelling about, oh my God, my broadband sucks and it's so expensive, is not going to get them to decide whether or not QoS on the last mile is a good idea. So how do we get the end users to do that? I don't know. What we actually need is more people in this room and rooms like this to write up things in a, you know, objective, non-emotional way that explain the real problem and get that in front of the people at Washington. And if you're interested, let me know and I'll see if I can get you up there.
Thanks, Patrick.
Thank you, everyone.